Securing Your Legacy, a guide to smart estate planning. My name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning. Today, we are going to be covering a smart estate planning guide to ensure that your legacy is what you want your legacy to be, at least when it comes to your estate planning documents being the right ones to support that legacy. What is estate planning? Do I even need an estate plan? What documents make up an estate plan, and what benefits do these estate planning documents have? What are their advantages and what are their disadvantages? And can I do it myself? Those are all questions and more that we are going to be covering when we talk about your estate planning smart guide. Legacy. Let's start with legacy and the meaning of legacy. And everyone's definition will be individual to them. It could be a life well lived. It could be positive contributions to your community, to your workplace. It could be your family. Whatever it is something that matters to you. For me, it's striving for all of the above, and being an estate planning and elder law attorney, I am truly honored in that I have the ability to help clients one-on-one, and I have this opportunity to educate and provide people information so that they can better understand estate planning, what is right for them, the importance of estate planning and elder law, and how that fits with ensuring that your legacy will be secure. However you define legacy in your life, well, that's the right definition for you. So beyond the definition of legacy, which is personal in what you want to be remembered for, how your life matters, most people will agree that estate planning is important to help ensure the legacy, the component of money and assets. We could be talking about making sure money passes where you want it to go, your home, a family cabin, legacy property. Could be a classic car or jewelry, investment property. Whatever it is that it makes up your estate, that also will be part of your legacy. That will help how you want it to help. Perhaps it is making sure that your adult children have some money from you such that they could, build the house that they want. It could be to fund your grandchildren's education. It could be making sure that that family legacy property stays in the family. Many things. It could be just whatever personal property is important to you, goes where you want it to go. I mean, really, the list is endless. So when we're talking about estate planning and legacy, we are going to be talking about that aspect of legacy, which really has to do with money and personal property and those things that are pretty tangible that we know you can pass down to those that you want to receive it if you have the right estate plan in place. So let's go ahead and focus on the guide to estate planning. The right estate plan for you is not something that we're going to be able to define today during an educational presentation such as this. But the right estate plan for you will do a few things. It will state your wishes. It will be clear. It will ensure that your assets go where you want them to go. And that, or it might not be to family, perhaps charities or other causes are really important to you. Your right estate plan will make sure that all of that will be accomplished. Let's talk about estate planning. What is estate planning? Sometimes it's referred to as putting your affairs in order And sadly, when we hear that, that usually comes with a terminal diagnosis, and somebody has waited or been told that it is time. There's no time to waste. Get your affairs in order. So I'm hoping that those who are listening today aren't in that place. I'm hoping that they are proactive and doing planning, because for some reason, you who are listening know that it's probably a wise thing to put an estate plan in place or at least learn more about it. One of the things I would say about estate planning is it truly is a gift to your family. And maybe you yourself have encountered this, that you had a loved one who passed away and they didn't have a good estate plan, or it, you experience the problems that comes when a person doesn't have an estate plan. And so you know that having your affairs having the right estate plan, having things set up correctly is going to ensure the best outcome when it comes to your legacy. Estate planning, what is it? It is legal documents that fit your individual situation, that will accomplish your goals, will make sure that your voice will be heard during your lifetime and after you pass, so that your wishes will be carried out. And they'll be carried out with authority, with clarity, efficiently as possible, which minimizes conflict and ensures that the assets are distributed as you want them to be to those beneficiaries, with either avoidance of estate tax or minimization, and with and in a way that protects your beneficiaries who might need protection. Not everybody should inherit outright, and we will be talking about that. So maybe that above list helps answer the question, can I do it myself? Maybe not. And as you hear more, maybe it will help guide you. Can you do this yourself? Another question is, do I even need an estate plan? People often think, I don't need an estate plan. I am not wealthy. I don't have a lot of money. And this is what I will tell you. It is not all about money. It is about making sure your voice is heard and that you are protected. The basic rule is, if you are an adult, you need an estate plan. It could be a simple estate plan, but you need an estate plan regardless of the assets that you may hold. Are you married? You need a plan. Do you have minor children? You need a plan. Is there any possibility that you could be in an accident or be injured or suffer a medical event that leads you to become incapacitated? If there's any possibility of that, you need an estate plan. And frankly, all of us must say yes to that possibility, though none of us want that possibility to happen. And lastly, let me ask, is there any possibility that you will die? Well, we all know the answer to that. It is not just a possibility. It is not a probability. It is a certainty. What we don't know is when that might occur. And so it's easy to say, I don't need an estate plan right now because I am alive. But you know what? When you are faced with an absolute certainty that something will happen, doesn't it make sense to plan for that when you can? Because frankly, none of us have that crystal ball and know what the future holds, except for we do know of that inevitable end to our life will come. So yes, everybody needs planning. If you don't plan, if you don't have an estate plan, what happens? The state where you live has a plan for you. And today, what we're talking about is the state of Washington, but this applies in any state. The state that you live in has a plan for you for what happens in the event of, number one, your incapacity. And this will be no surprise, you will be subject to a court-ordered guardianship and conservatorship. Number two, on your death, you have no plan in place. What happens? The state says, who gets your assets? That's it. So the state's plan most likely is not the plan for you. So do you need an estate plan? Well, frankly, you already have an estate plan. It's the state's one for you. So let's rephrase that. Do you need an estate plan that is a plan you want that accomplishes your goals? Yes, you need an estate plan. When is the estate plan needed? I think I pretty much just addressed that we really don't know when incapacity might strike us. We don't know when our lives might come to an end. So it makes it really easy to not put an estate plan in place that's our own plan, because it's like there's no urgency to this. So we just say, and this is very common, just ignore the necessity of it. But one of the things is, and I'll say congratulations to those of you who are listening, it means you are at least thinking about it would be a good idea to have an estate plan in place. Certainly as people get older, we tend to realize that at some point we definitely need our own estate plan. It becomes more real, and it starts weighing on people's minds when they don't have their estate plan. They start thinking about it and say, I really think I need an estate plan. So when it starts weighing on you, I think that's a really good indication to see somebody to give you peace of mind, give you that just knowing that you have the right plan in place for you. So can you do this yourself? Well, of course, my answer to that is no, you can't. You can put documents in place, but they are not going to accomplish the right estate plan for you that gives you peace of mind. That's where your estate planning and elder law attorney comes in. Because peace of mind isn't just documents, estate planning documents, it's understanding them. It's understanding how they operate, how they carry out your wishes. So more than just legal documents, estate planning is that guidance so that you understand what your options are. You get to select what you want through legal guidance. And with that, then you can have confidence in knowing that you have made the right decision, you have the right documents in place, and that's what gives you peace of mind. What are the fundamental estate planning documents that make up an estate? Well, there's a will and there's a trust. These are documents that for the most part direct where your assets go when you have passed. There's also durable powers of attorney for finances, for healthcare, and an advance directive. That's also called a healthcare directive. It's also called a living will. It all means the same thing. Those documents are what I call your living documents. The durable powers of attorney make sure that somebody can handle your affairs if during your lifetime you're not able to do so because of some incapacity. The advance directive, healthcare directive, living will, that puts into writing what your wishes are if you are at end of life. It says whether or not you want heroic measures or whether you don't want such measures to prolong the process of your dying. We're going to talk a lot more about these. I just wanted to give you a real quick explanation. The estate plan will also include coordination of your assets, so not documents per se, but an understanding that your life insurance policy goes by way of beneficiary designation, as does your IRA or your 401k. And so you need to understand what the beneficiary designation should be so that it is coordinated with your estate plan and it's filled out correctly so your wishes will be carried out. It's also important to understand titling of assets. For example, Assets that are held, like a bank account, joint tenancy with right of survivorship goes to the surviving owner of that bank account, regardless of what your will says about where things go. So you want to make sure that you understand that by putting somebody else's name on an account, especially with joint tenancy, that might not be consistent with what your wishes are. You might put them on an account because you want them to have immediate access to your funds when you die. It makes sense if the amount is not very large, under 10,000. But what if that's $100,000 an account? Now that has really interfered with what your dispositive wishes are as set forth in your will. All right. Estate planning documents, let's talk in more depth about what each one does. We are going to start with those documents that are the will and the trust. Everybody's familiar with those terms, will and trust. And when people say trust, they typically think of a revocable living trust. So we are going to be talking about those. So here we go. What is a will? As I said, you probably know this. A will says where your assets go when you are gone, who gets them, and who directs the assets, who's your executor, who's your personal representative. A will requires probate. Probate is the legal process to ensure that your wishes under your will are carried out. A probate occurs in the court. If we have time, we'll get into some detail about probates. If we don't, then I'm going to do another presentation about probates. But I want you to understand, and a lot of people don't understand this. They think, I have a will, there won't be a probate. That's the exact opposite. You have a will, and if your estate plan is set up to rely upon your will, there will be a probate upon your passing. Trusts, when people hear the term trust, they typically are thinking about a revocable living trust. And that's a document that you create, that you sign to create this trust during your lifetime. During lifetime is also called a inter vivos trust, but it's pretty clear. It's a revocable living trust. Revocable living trusts are very much favored by financial advisors because their primary benefit is avoiding a probate. So I want to just back up a little bit and mention that in your will, you can put trusts into your will, but a will has no effect until you have passed. So those trusts that in your will don't come into effect until your will is probate. And then there may be a trust you've created for your spouse, or a trust you've created for your adult children or for your minor children, or a trust for tax purposes, or even a trust for your pet, because all of those trusts are commonly found in wills. Those are called testamentary trust, or depends on your pronunciation. I say testamentary. Your will also indicate if you do have minor children who would be the guardian that you nominated, because the court will likely follow your directions and appoint that person as guardian of your kids if there's no good reason not to. The trust in your will for your minor children will also you'll have named who's the trustee who's going to be in charge of your minor child or children's money. So just because you have a will doesn't mean there aren't trusts involved. It's just that those trusts come into being later after your death. Contrast that to a revocable living trust, which comes into being when you sign it during your lifetime. Now, a revocable living trust is a legal entity which is intended to hold all your assets, manage your assets, and distribute those assets when you have passed. Because you're creating a revocable living trust, you are the grantor, also known as the trustor. That's the person who creates the trust by signing the legal documents and by making sure that these assets, their home, their accounts, investment accounts, any assets that can go into the trust will be in that trust. That's funding of the trust. The trustee of a trust is the person who manages the assets once a trust is created. The beneficiary of the trust is the person who gets all the benefits from the assets that are in the trust. So, for example, they live in the house, they're a beneficiary, they get money, they're a beneficiary. And all of this is according to the terms of this trust. So in a revocable living trust, it is very, very common for all of those roles, grantor, trustor, trustee, beneficiary, all to be the same person. That's typically how revocable living trusts will be set up. And it's a little bit confusing because it's supposed to be this own entity, but it doesn't really feel like that because it's just you and your money and you're managing it for your own benefit. You don't even need to file a tax return because this trust doesn't have a tax EIN number because it's not separated from you. It is you, but yet it is a revocable living trust. So that gives people cause to be confused about it. As I mentioned earlier, the benefit of an RLT, of a revocable living trust is that it manages assets and distributes assets when you have passed away and without the need for a probate. So that is the big advantage of a revocable living trust. I mentioned earlier when I was talking about wills that wills can have trusts within them. Revocable living trusts are the same way. They can have trusts that are designed to be set up when the grantor dies. And especially with couples, they often will have the assets of the deceased spouse go into a new irrevocable trust for the benefit of the surviving spouse. That can be a tax protection trust. So there are next stages after one of the grantor of the trust, or if the trust is for a couple after they die, there are next steps to be taken to management of that trust. And because the grantor who was the trustee has died, there's going to be a successor trustee who takes over that management. If it's a couple situation, it might just be the surviving spouse. That's oftentimes when trouble occurs because the surviving spouse doesn't realize that they need to take action to set up a new trust, and they don't go back to the lawyer to get any guidance because, you know what, they don't realize that they have to. And oftentimes people don't like to go see the lawyer and ask for help because seeing a lawyer costs money. So they don't understand that they're supposed to take action. They don't take action. And as a result, there can be some consequences that were not as intended, including the fact that estate taxes may become due. So if you have a revocable living trust, and if somebody has passed away that was the grantor of that trust, if you're in a couple situation, definitely go see the attorney who helped you set up that trust. Let's talk about a misconception of revocable living trusts. One of them is what I just said. You don't have to do anything further when life changes. You do. Another thing is people don't understand that trusts require ongoing management. The trust has no effect on assets that are outside of the trust. So if you open up a new bank account and you don't title it in the name of the trust, it's not controlled by the trust. What does that mean? That means the trust has nothing to do with it. On your death, that asset will go to either a joint owner or maybe under the terms of your will. And you might say, why do I have a will if I have a trust? You will have what's called a pour-over will when you have a revocable living trust. Why? Because not uncommonly, people don't fully fund their trust. So when they die, there's assets outside of it that need to be captured and go through the probate process, through the will, and put back into the trust so they can be managed. So that is one problem with revocable living trusts, is people not understanding the work that's involved in keeping them up. Another misconception about revocable living trusts is that they protect assets. Remember I mentioned that a revocable living trust has no identity separate of the grantor, no tax ID number. It's just like the grantor owns and manages and benefits from it. They do. That means there's no creditor protections, at least not in the state of Washington, which is what I am speaking to. I would encourage you, if you're in a different state and you think that your revocable living trust gives you creditor protections, to talk to that attorney in the state that helped you prepare that trust. You know, and another thing about trusts like this is that they can be revoked. And that is why people are so attracted to them, because you can change your mind anytime and just get rid of your trust. So that is another reason that revocable living trusts are attractive. But again, keep in mind the key reason people use revocable living trust is to avoid probate. I want to make a note about irrevocable trusts, which are different than revocable living trusts. An irrevocable trust can be one that is created during your lifetime. It can be a trust that is created by your will on your death or by your revocable living trust on your death. Irrevocable trusts have a much different rules. They will have their own tax ID number. The tax treatment of them will be different than if it was through a revocable living trust. They have a lot of extremely useful purposes. For wealthy individuals, they can give away their assets to this irrevocable trust to get those assets outside of their estate. Because if they are outside of their estate, then they are not within that person's estate when they die, so they're not going to be taxed for the estate tax. So for wealthy individuals, irrevocable lifetime inter vivos trusts are definitely something to consider. Irrevocable trusts are also something that are not uncommonly used for Medicaid planning. Medicaid has a 5-year look back. If you give away your assets to an irrevocable trust 5 years before you apply for benefits, that is fine with Medicaid, as long as you set up that trust correctly, which in states means different things. In Washington, it means that you did not remain in control, like as a trustee, and that you're not a beneficiary of the principal of the assets of that trust. Whenever you are looking at an irrevocable trust, remember I mentioned before, can I do this myself? I'm going to just tell you flat out, unless you're an estate planning and elder law attorney, an irrevocable trust by yourself is a horrible idea because it's irrevocable. You can't fix it. Lawyers have ways to fix irrevocable trust, but I got to tell you that involves a lot of time, effort, and that means money. So irrevocable trust, a great planning tool, not to be done on your own. Talk to your attorney to find out how an irrevocable trust, either a lifetime one or one through your will or through your revocable living trust, might be a really good idea from tax planning, from asset protection, and such. When it comes to trusts, and what I want you to start thinking about is, I heard the term trust, tell me more. What kind of trust is this? Is it testamentary? Is it created by my revocable living trust? Is it an irrevocable tax trust? Is it a trust for Medicaid planning purposes? All of those questions need to be asked when somebody says trust. And that's not part of our SMART guide today. I just wanted to share that with you so you were familiar with irrevocable trusts. I mentioned estate taxes. In the state of Washington, our what's called credit exclusion amount is $2.193 million in 2025. And it's been that way for a long time. So what that means is, let's say you're a single person and you've got under 2.193 million. When your assets pass to your beneficiary, say your family, they won't pay any estate tax. If your asset level is above 2.193 million, then there will be an estate tax paid if you pay it to a person. Charities have an exclusion. So you can pay to charity and not pay estate tax. The federal level is, as of this year, 2025, $13.99 million. That keeps going up and it keeps going up. The tax exclusion amount is set to sunset this year, 2025, but we have a new president, we have a new Congress. There will definitely be discussions in Washington about extending these tax laws that were put into place many years ago. So what will the amount be next year? I don't know. I don't have a crystal ball. Will it go down a whole lot, for the federal exclusion amount? I really doubt it. But that's what it is this year. If you have a taxable estate, which means 2.193 million in Washington, you definitely want to see an attorney to help you with tax planning. If you live in the state of Idaho, for example, they have no state estate tax. They're only subject to the 13.99 million. Still want to see an attorney to make sure your money goes where you want it to go, but the problem or issue of an estate tax is far less likely unless you have more than 13.99 million. Let's say that you don't have a taxable estate situation. Then what I want to talk with you about is estate planning documents that might be right for you if you have more concerns about long-term care costs, spending your money down. There are really excellent estate planning tools that you can put in your will for purposes of ensuring that you won't, or your spouse won't have to do a spend down in case long-term care is a concern. And frankly, depending on what your situation is, long-term care costs might be a much bigger concern to you than whether or not you're going to have to pay a state or federal estate tax. So this is why seeing an attorney is going to help guide you to make sure that your concerns are being answered, your goals will be met. So, and I do want to point out, even if you do have a taxable estate, you might not feel like you do. Look at the value of real property, especially in King County. You might have a home that is worth more than $2 million, and yet your liquidity is 500,000 or under $1 million. In that situation, and let's say you are older, you are a couple, you are concerned about long-term care costs, you might want to do estate planning that ensures that whomever is the surviving spouse of the two of you doesn't have to liquidate the home, doesn't have to move from the home just because they can't afford the home. If that's the case, what you're looking at is protecting money from, the real costs of long-term care. In order to do that, you are going to need a will. I just said earlier, a revocable living trust can be a great estate planning tool to avoid probate. But a revocable living trust in the state of Washington does not work to protect assets for your surviving spouse against having to be spent down for Medicaid long-term care. The only way to accomplish that is through your will. And you need to have a trust in your will. We call it a supplemental needs trust or an asset protection supplemental needs trust. But the mechanism for creating that trust has to be through your will, and it occurs upon the death of the first spouse. This will accomplish the following. Upon the death of the first spouse to die, their assets in a community property state, typically 50%, will go into the special trust for the surviving spouse. Sometimes we can accomplish even 100% asset protection, but let's just stick with the 50%. Through the will, by creating this trust, asset protection supplemental needs trust, which has effect upon death through a probate, you can ensure that your spouse will never become impoverished, will never have to lose their assets or spend down their assets because of their need for long-term care. So this is something that people get really confused about because they've all heard revocable living trusts are the way to go. They're the easiest, avoid probate. I am telling you the exact opposite. If you're concerned about making sure that your spouse is not impoverished after your passing due to long-term care costs, we need to take a look at a will with a supplemental needs trust, and that means there will need to be a probate on the passing of the first spouse. So it's because of the benefit. Medicaid will not count any of those assets that are in that asset protection trust created by the will of the first spouse to die. So what it does is it's almost like an insurance policy in that it ensures that if you leave your spouse, you will leave that person with money in a trust that never counts against them if they ever need to apply for Medicaid benefits. This type of planning doesn't say you must go get Medicaid. What it says is, do you want the Medicaid option available for you? In that event, then let's explore putting assets into the supplemental needs trust following the passing of the first spouse. See, one of the things that an elder law attorney works with all the time are people who are going through their later years and declining health and the need for care. So at ELG Estate Planning, we have Medicaid expertise. We help clients with this type of planning and filing the applications for Medicaid benefits, which means we understand Medicaid's rules. And we incorporate that into the estate planning documents that we do, depending on what the client's goals are, what their situation is. When a person is left as a widow or a widower, surviving spouse, Medicaid says you can only have $2,000 in countable assets. Yes, you can have your house and it can be worth over $1 million, but that house will be subject to the state's lien if the surviving spouse, this now single person, does need long-term care help and Medicaid benefits. So the real beauty of a will with an asset protection trust is it is a way to make sure that your spouse will never be impoverished. And that is really something that is important to a lot of couples, that they know that they provided for their spouse. That is one of the reasons that probate might be a really good idea. Let me just give you a really simple example so you can understand, because this is at a point where I usually get quite a few questions that say, how do I protect my spouse when I'm gone? Again, it's through a will. Can't do it through a probate. You can't do it through a revocable living trust. A will requires a probate. Let's just take an example. Let's say a couple has $2 million. Whatever it looks like, house, investments, funds, they've got $2 million. So in this example, let's say Sally and Steve. And Sally has advanced dementia. Steve is still alive. Steve is taking care of her. Fortunately, before her dementia got too far down the road, they did asset protection estate planning. And that means that they each have a will with a supplemental needs trust. Both of them do, even though it's only Sally that has the dementia. Steve's been caring for her at home. Things are going okay, though it's difficult. And then Steve dies. What happens? Sally can't stay at home anymore. We know that upon Steve's death, at least one half of this estate, which is $1 million, can go into a trust for Sally. And that $1 million that's in the trust, Medicaid will not count it as belonging to Sally, and therefore it doesn't interfere with her application for benefits. Because remember, she can only have $2,000 in countable assets. She can own the house outright, which is $1 million. So let's say that the house was worth $1 million, the other assets were worth $1 million. We put the $1 million liquid assets in the trust. Sally keeps the house. Sally is eligible for Medicaid with $2 million of assets with no spend down. Now, is Medicaid going to be the immediate option that she's going to need to have an attorney in fact act for her because she can't do this? Is that the immediate option that they're going to go to? Likely not. Probably going to look at memory care with a private pay period. So it's not that she will immediately go on Medicaid, but she can. And if, for example, there is a facility that is appropriate for her that doesn't have a private pay period, that accepts Medicaid immediately, there's a lot of facilities in Eastern Washington that do, or skilled nursing. Skilled nursing typically doesn't have any private pay requirement, then she's eligible for Medicaid, and Medicaid will pay for her care. The nice thing about that is they have options. Sally, that $1 million in a trust will never have to go and be spent on her care. At the end of the day, if she is on Medicaid and when she passes, the state gets none of those assets that were placed into this trust. And so they will go on to Steve and Sally's kids, as they had hoped would happen. And also, as I mentioned, there is a possibility to put 100% of those assets in this trust up to $2 million, given this couple's situation, the $1 million of the investment account and the $1 million of the house. All of that is possible. So a lot of people don't understand that there are planning options that are very beneficial for couples who are concerned about long-term care costs. So that is what I'm going to talk to you about when it comes to trusts, wills, and what happens on death. I want to turn our focus with the time we have left to living documents. Those are the estate planning documents that protect you while you are alive. Why they're important is they make sure that you will have your voice heard even when you can't speak because of incapacity. Your wishes will be known. Your money, to the extent it can be, will be protected. And you and that trusted individual who you put into the role of being your attorney in fact under your durable powers of attorney, that they will be in control. Because if you will recall, without having living documents such as your durable powers of attorney, should you lose capacity, the state's plan steps in for you, which is a court-ordered guardianship, conservatorship, where all your affairs are publicly, your care plan is put into the court. Your financial plan is put into the court. Your guardian conservator has to get court orders to take action for everything that happens. And all of this costs money through the guardian, if they're professional, through attorney's fees, the motions that need to be filed, on and on and on. All of this can be protected against if you have your own plan and not the state's plan. Your own plan, when it comes to your living documents, is pretty simple. Have your durable powers of attorney in place. What's the power of attorney? It is a legal document that you sign that says, I grant authority to whomever to manage my financial affairs. And if, for example, my husband can't do it, then it's my daughter. And if not my daughter, then it's my son. You have successor levels of people that you appoint as trustee or as attorney in fact. They're also known as agents or POAs. Basically, it means they can act on your behalf when you can't. Your power of attorney will grant authority over your financial matters, to take care of your bank accounts, to sell property if needed, to change beneficiary designations, whatever needs to be done. They can do it because you would want them to, because if you could, you would do it yourself. And you've appointed people that you trust. Some people say, I don't want to appoint anybody right now because I want to be in charge. Well, of course, as long as you're capable of being in charge, you will be. The attorney, in fact, is your fiduciary. They can't step in and take over for you when you don't want them to, as long as you have capacity. That's where sometimes it gets more difficult because the person thinks they have capacity and they don't. They're making a lot of mistakes. There is an elder law attorney can help walk you through how to make that a successful situation. But what I will tell you is if you are faced with the question of, should I make my power of attorney document effective immediately or later, springing on my incapacity? Always, I say, make it effective immediately because you trust that person. They can't act, and you don't want to have to put them through the situation of having to get doctor's statements saying that you're incapacitated. It's a really difficult situation to put somebody in. Elder law attorneys will agree, make that power of attorney effective immediately. Why do elder law attorneys agree with it? Because we deal with the situation all the time of what happens when people haven't made it effective immediately and all the problems that come up. So I just was mentioning powers of attorney for financial matters. You're going to want to have a power of attorney for healthcare matters as well. Obviously, the healthcare is to address your healthcare. If you are incapacitated and can't tell your doctors what you want, somebody needs to speak for you. There's a way the states plan, if you don't have a healthcare power of attorney, is that there is a hierarchy of who can speak for you for healthcare. But there is no such backup statutory protection if you don't have a power of attorney for your financial matters. And I want to point out, if you're married and you think you can act on your spouse's behalf without a power of attorney, that is not correct. You might think, I can act on behalf of my spouse. We're married, we're in a community property state. Both of our names are on that bank account. Okay, so maybe both of you can handle the bank account. And if your spouse loses capacity, you can still manage the bank account. But can you sell your house? No, you can't. If your spouse loses capacity and you don't have an effective durable power of attorney that gives authority to you or somebody else to sell the house, then your incapacitated spouse will be subject to a guardianship, and you need to work with their guardian. It could be you, it could be somebody else, to sell your house. And that's not easy. It requires the court to approve it. So what I'm saying is, don't think that because you're married, you've got it covered when it comes to powers of attorney. You don't, unless you have your own plan with your own powers of attorney in place. As an elder law attorney, I will also mention that when somebody in a couple loses capacity, sometimes that's when we're going to start looking into Medicaid asset preservation strategies, a way to qualify the ill spouse for Medicaid benefits. If we don't have a good durable power of attorney for that person, it makes it much more difficult for us to implement very effective strategies. So that is another reason to not do the power of attorney yourself. Have your durable power of attorneys drafted by an estate planning and elder law attorney who does understand Medicaid. All right, who should you appoint as your attorney? In fact, somebody you trust with your money and your life. And I don't mean that facetiously. You appoint somebody who you trust, who is capable, who will effectively carry out their job, that they have the ability to do so, the time to do so, that they are well suited to do that. So you want to appoint somebody who you know will do the job when that job comes up. The other living document that I haven't mentioned much is the living will. It's also called in Washington the Advance Directive. It's called more generally Healthcare Directive. That's where you put into writing your end of life wishes. By doing that, you're going to ensure that your voice will be heard. You're going to minimize conflict with your decision maker, your healthcare agent, as to what you want. That's going to alleviate guilt and the burden of maybe what's a really tough decision, such as, removing life support. The thing about an advance directive to keep in mind is it doesn't come into play until your attending physician or two physicians have put into writing that you are at end of life, that you are in a terminal condition, permanent unconscious. And so having an advance directive in place doesn't mean that you're not going to get all of that emergency care, all of the care that you need prior to that point. It's only when the doctors with reasonable medical probability have said that you are at end of life, then does that advance directive come into play that says what your wishes are. Generally, people's wishes are that they don't want to have the dying process prolonged. However, it's up to you. So what I hope that you take from this is that an estate plan is necessary. It can be done. I don't think it can be done on your own, but it is something that's important to put into place before it is too late. What is too late? Well, a death has occurred. That's too late. What else does too late mean? It means somebody has lost the legal capacity to put into place their necessary documents. Now, diagnosis of Alzheimer's or any cognitive decline diagnosis does not mean it is too late. Attorneys are required under the bar rules to act, to work with people with diminished capacity to the extent that it's possible. Elder law attorneys all the time work with people who have such a diagnosis. We know that that diagnosis doesn't by itself mean that they don't have legal capacity. Legal capacity goes away when that person doesn't and can't understand anything. Doesn't mean the fact that they have short-term memory loss doesn't mean that they lack capacity. So an elder law attorney has a lot of experience in working with people who have diminished capacity. Having said that, it is far better for you and your spouse to get your estate plan in place now, because you are thinking about it, because you know it has to be done. And I know there's so many reasons not to get it done. There's no urgency because who knows what the future will hold. Oh, if I have a lawyer do it, it's going to cost money. Absolutely. It will cost money, and it will cost money because it is worth the investment to protect yourself, your family, your money, your assets, and give you that peace of mind. And the services of an experienced elder law and estate planning lawyer, we charge for our professional services, as I know you expect that we would. Okay, we are coming up. We don't have that much time in place, so I am not getting into probate or the other things that I thought I might have time to cover today, because I'm not going to. I'm going to take a look at some of the questions. Confused between the advance directive and the pulse form. Are they the same? Thank you for posting that question. I actually did want to get to that today. They are not the same. An advance directive is where you say what your end of life wishes are. And typically it's in a big, long document, at least how we prepare them. And a lawyer prepares it for you. And it only comes into play when the doctors say you're at end of life. A pulsed is different. A pulse form, you've probably seen them. They're lime green. In Washington, at least they are. They stand for Physician's Order on Life-Sustaining Treatment. It is a document that you don't get from an attorney. You get it from your doctor, your doctor's office. It is intended to cover the situation of what happens when you stop breathing. Your heart stops. 911 is called. The emergency responders come to your house. First thing they're going to do is they're going to look at your refrigerator. Do they see a pulse form? And at the very top of it, it's either going to say to attempt resuscitation or DNAR. They're looking for that box. If it says DNAR, do not attempt resuscitation, the emergency responders are hands off. And for a lot of people who are, for whatever they are at in their life, be it their age, their frailty, their diagnoses, they know if their heart stops, that's the end. That's what they want. They don't want all of that. Sometimes what seems to be really brutal interventions that might bring them back, might not. They want DNR, so do not resuscitate. The pulse form has more to it than that. It says whether, if you want to be transported, do you want, ICU or do you want palliative, all that type of thing. That's something to talk about with your doctor. But that is how a pulse form is different, is that it is kind of the shorthand. Here it is in bold colors. Don't resuscitate. Again, it says more than that, but does a durable power of attorney ever expire? Great question. It does. When you expire, your power of attorney expires. So what that means is somebody who has been acting on behalf of the principal, the person who signed the power of attorney, and they've been managing their financial affairs and doing all of this, then the person dies. And then they think, well, I'm the power of attorney. I keep doing things. No, stop. You can't. Your authority is gone. It has expired. So that's what the next step is in the estate administration. Will there be a will and a probate? And until the court appoints an executor or personal representative, nobody has any legal authority. So that's why I mentioned earlier, sometimes people put a joint owner on a relatively modest account so that they can manage finances, because now they're the owner of that modest account. So, and that's really frustrating because people think, what do I do now? You're going to have to see an attorney that's going to help you. If there's a revocable living trust, there'll be authority under the revocable living trust as a successor trustee. One exception to does the power of attorney ever expire? Under a healthcare power of attorney, there is authority for the person, if it's written in the document, that they can manage burial if the person who died didn't already have burial directions. So the healthcare agent under a durable power of attorney for healthcare has a legal authority, and it continues after the death of the person who died to deal with burial, cremation, etc. Otherwise, yeah, durable powers of attorney expire on somebody's death. One more thing, durable powers of attorney can be revoked by the person who signed them at any time, as long as that person still has capacity. Once they lose capacity, they cannot revoke the durable power of attorney because they don't understand what they're doing. They don't have a legal authority. The reason it's called durable power of attorney, and you want your powers of attorney to be durable, is that that document remains in place and in effect, even though the person who signed it now has lost the capacity. So it has to be durable. All right, let me see if there's any others. Take a look at the chat if you're joining me today during this webinar. We've got a lot of resources. As I mentioned at the start, it's really important to me to get good information out that's understandable so that you can make your own decisions about your estate plan and have a guide to a smart estate plan. Thank you for joining me today. Again, I'm Lynn St. Louis with ELG Estate Planning. You can find us at elgwa.com. We have lots of resources. If you have questions for us, please reach out to us. We'd be pleased to be able to assist you. Thanks so much.